August 28th, 2019. I'm Peter Kaczynski, and on our video we have Commissioners Kellner, Spano, and Peterson. So we have a quorum. In fact, everyone's here for the meeting. We'll start today's meeting with the agenda, or the minutes, I'm sorry, from July 25th, 2019.
We don't have minutes for this one because
I have minutes in my packet. Should I not consider those today? Do not want to consider those today?
I didn't have them on the agenda. So.
Okay. All right. Well, we can put them off till the next meeting. They're not on the agenda, I'm told, so we shouldn't consider them. So we'll just put that off till the next meeting if the commissioners are okay with that. So we'll just move on to the new business for today. And the first item of business is the electronic poll book system vendors. We have new configurations for 2 of the e-poll books, No Ink and 10X. And the reports of the vendors have been submitted to the commissioners for our approval today. Is there any discussion or any motions?
I move that we approve the proposal.
Is there a second?
I second that.
It's been moved and seconded to approve the additional No Ink and 10X configurations. All in favor?
Aye.
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 Opposed? So that is unanimously adopted. Our next order of business is the Clear Ballot upgrade certification for the central count and automated audit tool. This is another upgrade to a voting system today that's before us. Is there any discussion or a motion on that matter?
I move that. Move the resolution.
I have a motion to move the resolution. Do I have a second?
Second.
Second.
All in favor? Aye.
Aye.
Opposed? And that is also adopted unanimously. And our final agenda item today are rulings on,
I'm sorry, Commissioner. Just only because
I'm sorry.
There were actually 2 proposed resolutions for that. The one was the certified as the voting system, and the other
Right.
one was to approve it as an authorized audit tool.
right, I think we incorporated both those.
Just want to make sure we did.
No, I mentioned both those in our preamble, so I'm thinking both of those were moved and approved. And then the final matter for today are the Prima Facie ballot access and specification objection report. We have a list of 15 items that were submitted to the commissioners for adoption, and these are related to ballot access for this fall's election. Is there any discussion on that matter? I would entertain a motion to adopt.
Could I just make, excuse me, Commissioner.
Sure.
On the last 3 items, maybe it's just a nitpick, but I believe that the objections in 13, 14, and 15 should be rejected, not just on the grounds that they, not precisely for the grounds specified in the report and in the draft orders. The draft orders suggest that the objections raise factual issues that the board should not rule on because we're operating in a ministerial capacity. Yet, in my reading of the objections don't even sufficiently raise those factual issues. They just make conclusory claims without any supporting factual allegations. And therefore, I think we should just reject the objections outright, as opposed to suggesting that they need to be resolved in a court proceeding.
I'd ask the staff that gave us this, is there any?
Well, in the determination, it only mentions that requires finding effects and just beyond our scope.
Mm-hmm.
It doesn't say it references to it to the court. I mean, I know we have that as a summary on the summary sheet, of the list of rulings. So there, some question of language there, but I'm not, sure.
My suggestion is that those orders say that the objection are overruled because they fail to specify sufficient factual allegations to support ruling the petitions and ruling the certificates of nomination invalid. It's a nitpick. I mean, it's not the end of the world if we stick with the drafted language. I just think that
Do you have the specs?
when I read the objections, they just
Let me take a look at
Are there
it.
specs here,
make
Tom?
broad conclusory allegations without any
I don't have the
facts
document.
that would support those allegations, and therefore, I think we should say that and reject the and reject them on that basis, and not just for the reasons
Okay.
stated in the proposed determination.
All right, I'd just like to take a minute, just look at the specs before we make a final determination on this. They're going to get the specs, if you could just hang out for a minute so we could take a look at them. So, just so I understand, Commissioner, this relates to both the objections to the Independence Party nominations and to the Working Families Party nominations?
Yes, I'm
Oh.
trying to open up the specs myself. which
Okay.
were emailed to
Okay.
me yesterday. And my recollection is that it was all three of them.
All right,
It's virtually the same language in the draft.
okay.
They use similar language in the.
Let's take a look.
Are they somewhere else for the court case, maybe? I think they took them out of there to put them in the folder for court, so
Okay.
how they're going to
Probably did.
round up the pieces.
I mean, we have to look at the specs, because
Yeah.
I don't remember them being insufficient. The question would be, if we reject the objections, does that impact their ability to go to court?
Could be. I don't know.
I think it was overruling the objection, so I don't think it's I think like prima facie, if you fail to do something timely to be a qualified objector, but I don't think we've come to that conclusion, only that if we overrule it, you're still a qualified objector to go to court.
That's right. I'm not suggesting that
A prima facie would say they didn't,
the objections, only
they're
that
not a
we
qualified objector. But if we just
by
overrule,
determination. So that the language in the determination is that the objections failed to provide sufficient factual allegations to form the basis for
Okay.
validating the certificate of nomination.
So is this, let's see, 8th, so term, okay. I'm just looking at the specs right now. So this is the specific to Gerald Whalen, Diane, Devlin, Cara Buscaglia, Chairman Frank McKay, okay, here's the specs. Chairman Frank McKay has no authority to name Charles Lamont as convener. Chairman Frank McKay could not delegate authority to choose the time and place of the Independence Party convention to any convener. Charles Lamont and no authority to act as convener. And or had no authority to choose the time and place.
Well, I guess my point, Commissioner,
Yeah.
is that allegation by itself, you know, to just say that someone has no authority,
Right.
doesn't spell out a sufficient basis for us to make a determination. In other words, he's not saying why he doesn't have authority, or he's not saying who does have the authority. It's just an unsupported conclusory allegation.
Let me just see. So these are so there's two objections to the Independence Party, and they're both the same objection by two different people. Is that correct?
One's by a DePaulo and one's by a Klesick.
Got it. And then the next one is to the Working Families Party.
Also in the 8th.
Okay. So you're saying the one to the Working Families Party is also insufficient? Is that your position? Because they are different. I mean, they're different in what they say. So the one for the Working Families Party is by Christine McInerney. Time and place of the JD8 Working Families Party Judicial Convention was called and set by Diala McManus. This violates the rules. No filing. Indicates David Chudney was designated, appointed, or named convener.
See, I don't think the determinations are incorrect in that it states that it requires finding of facts that we're really unable to do.
Okay.
And I'm not sure that the determination should be altered, because I think it just says, yeah, you filed them,
Right.
and we don't have the facts and the ability. It requires actions that we don't have the capability, or it's beyond our scope to do.
Well, see, I don't agree with that. I think that if they actually provided all of the proper documentation, that we could rule on it. We don't have to rule on it, but that we could rule on it. But they haven't provided that documentation and have not provided sufficient allegations. Maybe the Working Families Party is stronger than the other two, because she actually has a little bit more specificity of what it is that she's complaining about. But the other two are just conclusory. It's just one step better than simply saying we object because the certificates are invalid. They don't say why they're invalid.
I think with regard to the Working Family or any party, if they don't provide conveners to the state board, we give the roll call to the party, and it's their obligation. Certainly we give them to anybody who calls us and asks.
Right, we don't
a copy.
necessarily know who the convener
But if they don't
ultimately
give
is.
us a convener, it assumes, it says that they didn't give us the convener. Many don't give us the convener. So what? I mean, we give the roll call to the parties when they don't tell us when we have no other knowledge of who the convener
Right,
is.
it's the function of the party to designate the convener at some point. And if they tell us, then that's fine. If they don't, there's never been a penalty if they don't.
Right, but they're assuming that there is because they didn't tell us who it is, which I don't know for sure if they told us who the convener is in that party. But where the party doesn't tell us, any of the 8 parties, we send it to the party.
And I would have no information as to who the convener is.
So that's why I think they raise
Let me just give a hypothetical here. Suppose the party designates the convener and somebody else calls the convention and files a certificate. And they provide us, and the objector provides us with that documentation that the certificate that was filed was not by the proper convener designated by the party. I would rule on that, and I would reject, and I would rule on that factual issue based on the documents that are presented to us. And as I say, I'm nitpicking here, but I would simply ask that the determination not use the language that it uses here, that requires findings of fact and considerations of attendant circumstances beyond the ministerial scope of board review, but instead say that the specific objections do not allege, do not provide sufficient documentation to form a basis for invalidation of the certificate, or something like that. I'm very flexible on the language, as long as it doesn't suggest that we don't have jurisdiction to rule on it.
Well, I will say, reading these, I think there is a difference in the specificity of the objections for the working families as opposed to the independents. I think the one on the working families does go into more detail. It talks about the purported convener, David Chudney, called the roll. The convener was nominated. Subsequently, David Chudney called for his own nomination. And it alleges that the election of David Chudney is in direct contravention of the clear provisions of Election Law 6-126 that requires the convener to perform no other function, and that David Chudney acted beyond that. So it does appear to me there's more detail in that objection than there is in the other objection. I don't think I would lump them in together to that extent. There are more factual allegations made in that particular objection. So I'm not sure.
Well, except, all right, which one is the working families? Which number is it?
Number 15.
That's 15. That's the last one on our list.
So again, it says, the text of the determination says that it's beyond the ministerial scope of board review, when in fact what I would like is something to the effect that fails to provide sufficient documentation to support a finding that the certificate of nomination should be invalidated.
You're talking about the working families. What more would you be looking for beyond what was stated in the objection?
Well, why are we rejecting it? We're rejecting it because we don't agree that they have established that the convener had no authority to convene the convention. Correct?
I thought we were rejecting it because the finding was that the facts as alleged go beyond the capabilities of this board to make a decision regarding the legality of this, and that this was something that is beyond our ministerial capacity.
Why is that?
It's because it's...
I don't agree that we can't make a finding of fact on that.
Well, we don't know what happened at the convention. We don't know how the convener ended up doing that. We don't have the facts of how that occurred at the convention. We have the end result, but we don't have what occurred before that for that convener to begin that convention. So there's a piece we don't have.
So the reason we're denying it is because we don't have the documentation that would support an allegation that the person was not entitled to convene the convention.
And then the way we phrase that, or the standard language we've been using, is when there are documents or issues that are beyond us, it's beyond our ministerial scope. We don't have that in-house, so I don't have any way to do that. It's beyond what we would review. So that's been the standard language we've been using for quite some time. So, and this does not, you know,
If I could just add also, this is in court right now, and my concern is I would not modify these documents to the extent that it would remove, that would be the intent to invalidate the specs so that it would remove their ability to stay in court on the matter.
Well, we're invalidating this.
I'm not
If you
seeking
overrule
to
them.
invalidate the specs.
Right.
I'm only seeking to modify that language.
Right, well, as long as that's the intent, because again, my only concern is I wouldn't want someone to be able to raise that. We basically take a hands-off policy and they'll quibble about it in the courthouse, which is where they are literally right now.
But we've overruled, you know, when they've said a petition is invalid for insufficient signatures and you don't agree with them, we haven't,
Right.
they don't lose their ability to go to court to continue as a qualified objector, as long as they brought their case timely.
Right, I just don't want to invalidate the specs. Is my
Yeah, I think that's the distinction, though. I think it's not whether we're ruling the petition in or out, but whether we are ruling the specifics are sufficient. And you're suggesting they're not sufficient, Commissioner?
They don't provide documentation to support that allegation.
but if they never filed a list of conveners with us, there would be no documentation for them to provide.
I agree. Well, and if they want us to rule it invalid, they'd have to provide that documentation. And if they did provide the documentation, I would not decline to rule on it. I would rule on it and say that the convener was not authorized to convene the convention.
So let's just go through this for a minute. So on this one, they are alleging that the convener called the delegates, and then the convener was nominated and elected temporary chair. And their allegation is that the law does not allow a convener to be elected the permanent chair of the convention. So then the decision is that enough to invalidate the convention? Am I correct in characterizing what they're alleging here?
No, you are correct.
So, Commissioner, you're saying that if what the objector is alleging is true, that you would be prepared to invalidate the convention based on those allegations? But you don't feel they provided you sufficient factual detail to make that determination?
You know, I'm now seeing your point, because the other side is not here to say, wait a minute, that's not true. And so we would then be accepting as true an allegation without due process to the other side.
Yeah, I think there would have had to have been a hearing on these. Neither,
That's right.
you know, we didn't have a hearing on either one of them, which I agree would have given the two sides an opportunity to come in and present the case as they felt, and that was not afforded to anybody in these cases. Is that correct?
Correct.
So, I mean, I'm just uncomfortable changing the rules sort of at this point. We're at the commissioner level, and the hearing's time has already lapsed, and there wasn't a hearing.
I
To
think
flesh this out more?
I mean, we've talked about this wording, and we try to come up with wording that, and that, you know, that is acceptable to the four of you, because it is your determination. And that's why we say generally beyond. I mean, could we do some of that work? But in every instance, it's hard to be judge and jury and take in documentation beyond the four corners of
Well,
what
we
the
don't
law
take- I mean-
requires them to give us in the first place.
I mean, we don't take testimony at hearings.
And that's why when we,
I get that. I mean, we never have, and I think that is beyond our ability as a board to take testimony, and basically then you're really making decisions based on credibility of the witnesses. That is not the role of an administrative agency. I think that's always been seen as the role of the courts to determine when you have disputes of facts, whether or not you believe this person over that person. So in that sense, I can see where a hearing wasn't warranted, but I'm just trying to understand our position today. I don't want to deny people their rights.
On 15, I'm willing to yield. I think that's right. But now let's turn to 13 and 14.
Okay. All right, so 13 and 14 are the same. They're two different objectors, but I believe the objections themselves are the same. Is that correct? So let's look at that one first. So Chairman McKay had no authority. Chairman McKay could not delegate. Charles Mott had no authority to choose time and place. Process used for naming conveniently.
Now, so what I'm suggesting with respect to that one
Okay.
is that to simply say he had no authority, and without saying who did have the authority, and to provide documentation or some citation to that, they do not make sufficient allegations a finding of invalidity.
So what's our, I see they are different, so this is a different objection.
They are different, and again, we never got a list of conveners for this party, so we don't know who the convener was. They do reference the chairman of the state committee as to whether or not he had, what authority he did, or how he did his delegation of who ended up being the convener, which the rules, we can take on notice who the chairman of the party is. I don't think that's an issue.
Mm-hmm.
So I don't know what more would be sufficient, because what they're asking us to do is to go into the designation of the convener, which we would never have seen if we were never provided a list, and then make a determination as to whether that was done properly. We have no idea and no way to get that information on the document, so that's why it's beyond our scope, and that's why the language is this way. To suggest that the objections are insufficient, sets up a new threshold for us to determine insufficiency of objections, not just in this instance, but in many other instances where we have objections that are a little vague, shall we say. Although I think this provides some allegation. The question is whether it has a sufficiency of an allegation. And our answer is, well, we don't know, because we don't have all the facts and we have no way of getting them. We didn't set up a hearing, so I don't know what they would have brought in. I really don't know, because it would have been something that occurred prior to the convention, so it would not necessarily be reflected in the minutes. So there's something missing here, and that's why it's beyond our scope, because we don't see it.
I guess it's a question of what
That's what I want to say in the determination.
I'm sorry, do you have language that you want to say in the determination?
That the objections fail to provide sufficient factual support for finding of invalidity of the petition, of the certificate.
Objections have to be. I mean, in my experience, the general objection says nothing more than I hereby object to the nomination or designation of such and such a candidate to such and such an office, period. That's the general objection. then the specific objection has to give me some detail as to what my objection is. In this case, they are saying that Frank McKay had no authority to name Charles Lamont as convener. Frank McKay could not delegate authority to choose time and place. Charles Lamont had no authority. So they do give more specifics of what the objection. I didn't see the general, but I'm presuming it was pretty perfunctory as I outlined. And now this is giving us more detail as to why that nomination should be rejected. It doesn't provide every detail about why the chairman had no authority, but it does provide us with the allegation that the chairman had no authority, could not delegate the authority, the convener had no authority to act as convener. So they make the allegations to that extent. And you're suggesting you don't believe that's sufficiently specified.
It doesn't say why he has no authority or who does have authority. And that's conclusory. If that were a pleading in front of the judge, you would reject that. And I'm not suggesting that the spec is invalid. I'm simply saying that based on the information supplied, it's not sufficient to justify a finding of invalidity.
But isn't that the same thing as saying it's invalid?
We're overruling the specification. We're not finding the certificate of nomination invalid.
No, we're not. I mean, the proposal that was given to us was not to invalidate these. It's to...
No, it's to say it's beyond the ministerial scope of board review. And
Right.
I don't agree.
And you don't agree with that? You don't agree it's beyond our ministerial...
No, I believe that they failed to provide sufficient information on which to make a ruling.
That's a ruling on the objections.
I'm just trying to understand the level of responsibility here that you're imposing on these objectors. So they would have to come in with actual proof in the spec itself as to why the allegation that Frank McKay has no authority is true. They have to give us that information as part of the spec.
Right.
And they would have to give us why Charles Lamont had no authority to act as convener. We'd need that in the spec itself.
That's correct. That's what I'm saying.
But we've never had
Now,
that standard.
failing to provide that, it just doesn't provide a basis for us to rule that it's...
See, I think that's, I mean, in my view, that's what happens at a hearing, is, you know, you give me this information, and then at the hearing, had we had one, which we didn't, the objector would have to come in and show why McKay had no authority, why Frank McKay had no authority, and then the candidates would have the ability to come in in the context of the hearing and demonstrate why he did. And that would then become the subject matter of the hearing, but wouldn't necessarily be put out chapter and verse in the context of the spec itself. Like, if I object to a petition based on residency or something like that, I would say they're not a resident of the jurisdiction, let's say. That's my objection. But then at the hearing, I would have to come in and demonstrate that, where the candidate would have the ability to come in at that same hearing and say, no, I am, and here's proof of that I am. But the objection and the spec didn't necessarily set out chapter and verse why I think they're not a resident. It would merely state, I think you're not a resident, but the hearing would give you that ability to come in with the further proof as to why I'm asserting that, while the candidate has the ability to come in and make their counter-argument. That's my view of how the objection process works. So the specifics, and you understand, as you I know do, we're dealing with laymen often here, so you know to hold them to a standard of a court pleading, I'm not really comfortable with, because we don't always have attorneys that are objectors or even representing objectors. These are many times laymen who don't understand the rules of courtroom decorum and how you would make a case in a courtroom. to hold them to that standard that you have to specify everything out, I think it's a high standard to hold, and it's the hearing that really has that fleshing out of the allegations and the ability to defend yourself. That's my vision of how the process works. That said, I guess I'm comfortable with what we have in front of us to make a determination. I understand they're in court now, is that what you said? So I'm sure they're going through a lot more detail in court, and the court's holding them to whatever standard, but I'm just not comfortable holding these objectors to that high a level when they file objections with us. It sort of obviates the need for a hearing, in a sense.
Well, I suggest then that you rewrite the determination to simply say that we're denying it, and then we can have separate concurring opinions. I'll write 2 sentences. You can use this language or whatever other language you want. I think we're all agreed that we're finding that that we're overruling the objection to the certificate of nomination. But I don't agree to this language that it's beyond the ministerial scope of board review.
Okay, and again, I don't know that I would use the word overruling. I think what we're doing is we're deferring to another body, in essence the courts, to determine the validity or invalidity of the certificate before us, because the matter that was raised in the context of the objection is beyond the ability of a ministerial body to rule on.
And I don't agree that
Okay.
that's the case.
Okay. Well, I think that's where our difference maybe comes in then, as to whether or not this board has the authority to rule on matters of this nature.
Well, and we're also setting a standard that the objector did not know about after they filed their objections. There was no regulation that says, here's what your specs have to be, you know, or what the detail level of it. I think we should be uncomfortable changing that well after they filed everything without an opportunity for the parties to be heard on that.
Well, we have regulations, don't we, on specs?
We do, but it doesn't go into
They don't go to this extent, they don't
amount of
address.
documenting. No, it could never do that because, you know, it's more the format of what you provided for us.
Actually, the New York City regulations on specifications do have a paragraph that says that where factual information is required to support the objection
Where is
that's not
ours?
in possession of the board,
6204.
that factual information has to be attached to the specification. It's something along those lines. I didn't quote it. So look, as I say, I don't agree in 13 and 14 to the language in the determination. I don't object to the substance of the determination, but if you want me to vote in favor of it, I'm not going to vote in favor of that language in the text of the determination.
Okay. I would just note that the state board's regulation 6204.1 speaks to specifications, but it speaks only to specifications to designate and independent nominating petitions. I don't believe we have
Regs for nominations.
regulations that relate to this specific type of document. That does list out how you're supposed to do your specs for a petition, but this is not a petition. This is a certificate of nomination and minutes, and our specs really don't speak directly to that, so I don't think we have a regulation we can look to give guidance to people on this particular topic.
Well, this objection actually goes towards what the party did to assign the convener to the convention. It's not even in the certificate of nomination or in the minutes, it's the action that occurred before that by the party. That's what the objection is against. That he didn't have the authority to set this convener. The convener's listed there, it's just saying, well, whatever happened before is improper.
Right.
Like, well, we don't have any of those documents. We have no way to look at it, we have no way to bring the parties in. I mean, that is really a matter that is beyond our purview.
Okay, well, I'm comfortable with what we have in front of us, but I know Commissioner Kellner, you're not. You want to, now, let me distinguish these. Are we still speaking about the last one on the Working Families Party, or have you agreed to that one?
I'm withdrawing my concerns
Okay,
about that.
so we'll go back then, you're talking about
13 and 14.
13 and 14, which are the specs to the Independence Party nominating convention. There were two separate sets of specs, but you're making the same contention on both sets, that they're not sufficient in detail. But I'm comfortable that they are, for our purposes, sufficient, and that, again, this would have been fleshed out in a hearing had there been one. But you then agree with the conclusion that we should leave the certificates valid, but you don't agree with the language in the determination that was written by the staff, and I do agree with it. I don't know where the other two commissioners are, but I think as far as the ruling of the board, we can agree that we would support a ruling that these are valid as of today, because we are not ruling them invalid. But then
Correct.
you would want to have different language in the determination.
Correct.
So we may have to have more than one determination, even though the conclusion's the same, the wording in the determination would be different. Is that fair to say?
Right.
Okay. And I don't know about the other two commissioners, if you have any thoughts on this. I'm thinking you had some time to maybe look at this while we're speaking here, and if you have any thoughts, I'm certainly interested.
My thoughts are that the determination is the most important aspect of this. That's my opinion. And I have, you know, I have no opinion on the reason for it.
Okay.
I agree. For the purposes that we're convening today, I have no problem with it. However, I do understand Commissioner Kellner's objections, and for him to insert an additional determination on those particular two, the 13 and 14, I certainly would not have any objection to that.
Okay. Well, then let's do it this way. I think we can rule on the report given to us by the staff. If I'm willing to entertain a motion that we would adopt the report, the summary report that was supplied by the staff as written. And then if Commissioner Kellner or any other commissioner wants to have a separate determination on those two matters, that would of course be within their rights. I personally would support the one that was submitted.
So we would approve this one, but then allow a minority determination?
I don't know if it's minority, it might be
I
just
would call it a concurring. Why don't I
concurrence,
just
okay.
say two
That makes
sentences and say, Commissioner Kellner concurs in the result, and then I'll write one or two sentences that say that I would rule that the certificate of nomination remains valid because the specifications of objections do not supply sufficient facts
okay.
on
Well,
which the board could make a
We actually have done that.
Yeah, you'd certainly be allowed to submit your own
Concurrence, right.
language in the concurring.
But would
Opinion.
would the co-executive director sign the version that was before you?
I I believe that my concurrence should be above the signature of the co-executive director.
Is that acceptable to all of you? So
Yeah, we
you
could
know
do
what we
that.
would
if
do?
that's- Yeah, I think it should be included, I agree, in whatever document
Okay.
is provided by
Just so
the
we put it
board.
in and we can get it out.
Commissioner Kellner has a slightly different,
And I don't believe that should impact the court proceedings because the Commissioner indicated it's not his intent to reject the specs, it's just merely speaking of.
that's fine. Okay, all right, so if we're all in agreement on that, I would entertain a motion to adopt the report as provided by staff with that one amending provision.
So moved.
So moved.
All in favor? Aye?
Aye.
Opposed?
Aye.
Then it's all agreed upon. And according to my agenda, that is the last item that we have on the agenda, unless there's any other items to come before the board today, or any need for an executive session, which I don't believe we have. Is there anything else? No? Okay, then I would entertain a motion to adjourn. And our next meeting, I believe, is scheduled for October 2nd.
It's regularly scheduled.
Next regularly scheduled, although there may be the need for intervening meeting, but that'll come from the staff if that's needed. But as of today, we'll adjourn until October 2nd, 2019. Is there a motion?
So moved.
All in favor?
Aye.
Okay. Thank you, commissioners.
Thank you so much.
Okay. I think we're done here.
Tom, these were copies of the specification?
Oh, I'm sorry. I
Thanks
got
for
all
using
that.
Or the
WebEx.
originals?
Visit our website
You have
at
copies of subject.
www.webex.com.
You can take them.
I just,
Are we done?